The Supreme Court just issued a near-unanimous ruling that is already reshaping how gun laws are evaluated across the country, and most gun owners have no idea it even happened. An 8-1 decision, delivered quietly, without the kind of media coverage you'd expect for something this significant, just answered one of the biggest unanswered questions left behind after the Bruen decision. And that answer is now being applied to more than 100 active gun law challenges in federal courts right now. This ruling directly addresses when firearms can be taken, who can be temporarily disarmed, and what the Constitution actually allows governments to do when they claim someone is dangerous. And yes, depending on the situation, firearms worth tens of thousands of dollars can be seized under this framework. The court just decided whether that is constitutional, and the answer is going to surprise a lot of people. If you own firearms, if you follow gun law cases, or if you've ever wondered how far courts can go when balancing public safety against Second Amendment rights, this ruling matters. What I'm about to explain will change how you understand modern gun law, and it will affect how courts rule for years to come. The case is United States versus Rahimi, and the vote was 8-1. Chief Justice Roberts wrote the majority opinion, and what makes this decision remarkable isn't just the outcome, it's the coalition behind it. The court crossed ideological lines in a way we almost never see in Second Amendment cases. Over the last 5 years, fewer than 12% of Supreme Court gun cases have produced this level of agreement. Most Second Amendment decisions pass by the narrowest margins, 5-4 or 6-3, leaving lower courts divided and gun owners stuck in legal uncertainty. This time, nearly the entire court agreed on the framework. Justice Clarence Thomas was the lone dissenter. And here's the irony that almost no one is talking about. Thomas authored the 2022 Bruen decision. He created the historical tradition test that has reshaped gun law nationwide. And now in Rahimi, he's warning that courts are applying his own test too loosely. To understand why this matters, you have to understand the chaos Bruen created in the lower courts. Bruen required that modern gun laws be justified by historical tradition. If a regulation didn't have a historical analog from around 1791 or 1868, courts were instructed to strike it down. That sounded straightforward, but in practice, it threw the federal judiciary into disarray. Judges were suddenly expected to become historians. Some demanded near-perfect historical twins from colonial America. Others accepted broader analogies. The result was wildly inconsistent rulings. In some circuits, gun laws were being invalidated at rates approaching 70%. Domestic violence firearm prohibitions were struck down. Possession restrictions for people under restraining orders were invalidated. Entire enforcement frameworks were thrown into question. Gun owners weren't just watching legal theory unfold, they were paying for it. Defending a federal firearms charge routinely costs $75,000 or more. Over the past 2 years, gun owners have collectively spent an estimated $180 million in legal fees because courts could not agree on how to apply Bruen. Rahimi was supposed to answer a narrow question. Can the government temporarily disarm someone who has been found by a court to pose a credible threat to another person? But the court went much further than that. It clarified how the historical tradition test works in the real world. Chief Justice Roberts wrote that courts are not required to find identical historical regulations. They only need to identify historical principles that addressed similar problems, even if the mechanisms were different. The founding generation disarmed dangerous individuals using the tools they had at the time. Modern courts are allowed to do the same using modern legal tools. In Roberts's words, constitutional law cannot be trapped in amber. It must adapt while remaining faithful to founding-era principles. That single clarification changes everything. This ruling immediately affects 21 states and the District of Columbia that currently have extreme risk protection orders, commonly called red flag laws. Before Rahimi, many of these laws were on shaky ground. Gun rights organizations were actively challenging them, and several cases were moving toward likely victories. States like Missouri, Montana, Florida, Colorado, Maryland, Connecticut, California, Oregon, Washington, and New York were watching closely. Millions of dollars had already been spent defending these statutes, and more challenges were on the way. Then the Supreme Court stepped in. Rahimi validated the core constitutional framework these laws rely on, and the reaction was immediate. Montana's Attorney General announced plans to strengthen their protective order system. Florida and Colorado began expanding enforcement mechanisms. Legislators in multiple states who had been hesitant suddenly fast-tracked new proposals, now confident they had constitutional backing. The financial implications alone are massive. Collectively, these states were spending an estimated $85 million per year defending red flag laws in federal court. With the framework clarified, that money can now be redirected toward implementation instead of litigation. Just as important, the 29 states that do not currently have these laws now have a clear constitutional roadmap if they choose to pursue them. Whether you agree with that policy direction or not, the legal uncertainty that fueled endless litigation has been dramatically reduced. But this ruling doesn't just affect state laws, it has enormous consequences for federal enforcement. The Bureau of Alcohol, Tobacco, Firearms, and Explosives employs roughly 2,000 special agents nationwide. That's 2,000 agents responsible for enforcing federal gun laws across 330 million people and nearly 4 million square miles. Do the math. Each agent theoretically covers 165,000 people and nearly 2,000 square miles. Federal enforcement at scale is impossible without state and local cooperation. Internal data shows that approximately 73% of federal firearms prosecutions originate from state and local law enforcement encounters, not independent federal investigations, traffic stops, domestic calls, local arrests. That's where federal cases begin. In states where officials choose minimal cooperation with federal enforcement, those cases collapsed. Missouri experienced this firsthand. When its preservation approach was active, federal firearms prosecutions dropped by roughly 180 cases per year. That translated into over $13 million in avoided legal costs for Missouri gun owners in a single year. Rahimi reinforces the legal authority states rely on when deciding how and whether to cooperate. Federal enforcement becomes mathematically impossible without state participation. To compensate, the ATF would need to increase its workforce by more than 300%, requiring a budget increase from roughly $1.7 billion to nearly $6 billion annually. That's not politically realistic. Now let's talk about Justice Thomas's dissent, because it matters more than people realize. And Thomas argued that the founding generation addressed dangerous individuals using surety laws, not outright weapon confiscation. He wrote that not a single historical regulation justifies the statute at issue in Rahimi. In his view, the court has opened a door that may be impossible to close. His concern is the slippery slope. If courts can temporarily disarm someone based on a judicial finding of dangerousness, what prevents that standard from expanding? Could it eventually apply to lesser threats, to vague allegations, to unpopular speech or associations? Thomas is warning that once courts move away from strict historical matching, discretion grows. And discretion, he argues, is where constitutional rights erode. Gun rights organizations found themselves in an uncomfortable position in this case. The defendant's conduct was extreme. He repeatedly violated restraining orders, fired weapons in public, assaulted his partner, and ignored court directives. Many organizations quietly acknowledge that this was not the ideal test case. There's also a reality that often gets ignored in these debates. Polling shows that roughly 79% of gun owners support prohibiting firearm possession for individuals under domestic violence restraining orders. That's gun owners, not the general public. Data also shows that domestic violence victims face a dramatically higher risk of being killed when an abuser has access to firearms. The court did not invent that reality. It acknowledged it within a constitutional framework. Now, consider what this ruling does to the hundreds of pending cases working through federal courts right now. Assault weapon bans in Illinois and major cities are under active challenge. Age-based restrictions on handgun purchases, have already been struck down in some circuits and are heading towards Supreme Court review. Nonviolent felons convicted decades ago of fraud or tax offenses are challenging lifetime possession bans. Sensitive place restrictions involving bars, schools, government buildings, and public venues are being litigated aggressively. Rahimi doesn't decide all of these cases, but it gives judges a roadmap. Courts must now ask whether the challenged law addresses a problem the founding generation regulated, even if the modern solution looks different. That distinction matters. Legal analysts expect red flag laws and domestic violence firearm restrictions to survive most challenges. Age-based restrictions will produce mixed results. Assault weapon bans still face serious hurdles, particularly regarding common use. Sensitive place restrictions are on stronger footing, but scope will be critical. The financial stakes are enormous. Gun manufacturers face potential market restrictions valued at more than $2 billion annually. Legal defense costs for pending challenges are expected to exceed $400 million over the next 3 years alone. So what does this mean for you if you're a law-abiding gun owner? Your core rights remain extraordinarily strong. The right to possess firearms for self-defense in the home remains untouched. The right to carry firearms in public for lawful purposes remains protected. The government still bears the burden of justification for any restriction. But certain situations now clearly fall outside Second Amendment protection. If a court finds, based on evidence and due process, that you pose a credible threat to another person's physical safety, temporary disarmament can pass constitutional scrutiny, not based on status alone, not based on opinion, based on conduct and judicial findings. The Second Amendment protects rights, not abuse. Chief Justice Roberts summarized the balance clearly. The Constitution protects more than just 18th century weapons, and it permits more than just 18th century regulations, but it does not allow unlimited discretion. For responsible gun owners, this ruling does not weaken your rights. It stabilizes them. It reduces the chaos. It brings consistency where uncertainty reigned. For individuals who use firearms to threaten, intimidate, or harm others, courts now have clear constitutional authority to act temporarily. This decision fundamentally reshapes how Second Amendment challenges will be decided going forward. It replaces confusion with structure. It replaces historical scavenger hunts with principled analysis. And it signals that the Supreme Court is not interested in endless doctrinal whiplash. The question now shifts from whether gun laws must have identical historical twins to whether they reflect founding-era principles applied to modern realities. And that is a change that will echo through the courts for decades. So here's the real question for you. Does this historical analog approach strike the right balance between protecting gun rights and allowing reasonable safety restrictions, or does it give courts too much flexibility to restrict Second Amendment freedoms over time? Drop your honest thoughts in the comments. This conversation is far from over.